All rise. Court of Appeal in the 4th, 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
Thank you. You the keeping the clock?
Yes, sir.
Okay, good morning. Welcome to another session of oral argument at the 5th District Court of Appeal. For the record, it's Tuesday, June 16, 2026. It's 10:01 right now. Marshall just introduced me. I'm Brian Lambert. I'll be presiding over the OA this morning. We have one OA case this morning. Our other case was dispensed with. Let me introduce the panel. To my right and to your left is Judge Jim Edwards. To my left and your right is Judge Adrian Saub. Okay, like I said, we have one case today. Each side will have 20 minutes to argue. The appellant will have the initial and rebuttal if you want to use rebuttal. We typically will set 5 minutes for the rebuttal time. If you want to use more or less of that, just let us know, and the marshal will set the clock accordingly. The yellow light will go off when you're at the podium. If you are into your rebuttal time, you can continue going. You don't have to stop if you want to keep going on whatever topic you're talking about at the time, or if not, you can stop, that's fine, but you don't get more than 20 minutes. If you have a phone or any other electronic device that may go off, please put that either in the mute or silent, or turn it off so that you don't interfere with either your oral argument or your opponent's oral argument or the court's questioning of you. Okay, and also just beware, we are being we're on YouTube, so the vast numbers of people that watch us on YouTube for oral arguments, so just keep that in mind when you're making your comments, because people are watching you. So, all right, one case, 25-1406, B. Ray Gupta, I apologize if I'm mispronouncing, MDPA, DBA Florida Center for Plastic and Hand Surgery versus Blue Cross and Blue Shield of Florida, Inc. and Department of Management Services. So, counsel, if you're ready.
May it please the court.
Yes, ma'am.
Good morning. My name is Erin Newell, and I represent the appellant, B. Rai Gupta, MDPA, which is doing business as the Florida Center for Plastic Surgery and Hand Surgery. I would like to reserve an additional minute for rebuttal to make it 6 minutes instead of 5, please.
That's fine.
Thank you. So this case, really, I'd like to start with the big picture rather than getting into the minute details, which I know the appellee is going to be focusing on. So the big picture of this case, as per the amended complaint, which of course, that's going to dictate the facts of this case for the purposes of this appeal, since it was dismissed at the pleading stage. So we have a doctor who's providing emergency services here. My client removed retained hardware and revised non-healing intraoral wounds in this patient's mouth. They were deemed medically necessary. There's no issues regarding whether this falls within the covered benefits, whether this was an issue of coverage. Now, in that big picture context, it's important to understand the roles of the parties. Of course, as I've already mentioned, the appellant, Dr. Gupta, is a medical provider. He did provide emergency medical services. We have the appellee, Florida Blue, which processed the claim of that patient, okay? Florida Blue is the administrator of the insurer, so that's
So do you concede not the insurer?
Correct, and the relationship of the administrator and the insurer is going to be really important as we delve into the details of the argument. But big picture of the players is that we have this non-network allowance schedule that has been set by the administrator, which is the appellee, Florida Blue, and we have our third player, of course, the insurer, right? So if this is a self-insured plan through the state, the department has agreed, as the insurer, to accept the non-network allowance schedule that is being set forth by Florida Blue. So yes.
Were they required to accept that, or did they choose to accept that?
So per the contractual language, and we do have, the amended complaint does actually attach the full policy. So that's a difference between the initial complaint and the amended complaint. So if you're looking at page, I believe it's about 939 in the record, that's attachment exhibit A. That's where it gets into this relationship between the administrator and the insurer, and it does say that the department is obligated, it essentially agrees to accept those rates that are set in the non-network allowance schedule by Florida Blue. So we have these three players involved in the big picture of, in Florida, we want people to receive emergency services, of course, and we want them to be able to receive them regardless of what their insurance status is. Are they in-network? Are they out-network? Unfortunately, as someone who moved from Massachusetts, I think that this has been a struggle in Florida of how much the insurance companies or insurance in general really does sometimes dictate medical decisions. So the legislature, wanting to take care of Floridians, kind of creates this statutory strategic concession with medical providers, right? Whereas medical providers are absolutely required, there is a duty that physicians must provide emergency services irrespective of insurance, non-network, out-of-network, regardless. That care must be provided on its face, okay? And that's in the statute, it's in Chapter 395, that's not really mentioned specifically in our briefs, but it's important to acknowledge that duty because the concession on the other side is central to this case, and that's in Chapter 641.5135, right? So the concession is that the insurers must actually pay fees to these medical providers. A non-participating provider is still entitled to be paid, and subsection 5 of 641.513 sets the standard for that, right? It's going to have to be, per statute, the lesser of the provider's charge, which in this case was $34,951. That's alleged in the complaint. That's what was charged by Dr. Gupta. Okay, that's at page 912 of the amended complaint, right? Or the usual and customary provider charge for the community, or if there's a mutual agreement to the charge between the provider and the HMO. So those are the options, and it has to be the lesser of one of those. That didn't happen in this case, so when we're looking at the big picture, I think it's really important to recognize that you have this medical provider. He's trying to provide this emergency service. He's rewiring a person's jaw and solving a non-solvable wound, right? So, and then he's getting paid. So Florida Blue did process the claim, as I mentioned. No issue of whether this fell within coverage. It processed the claim for under $2,000. So you have services that cost the provider almost $35,000. Okay, and you're getting a reduction, you're getting paid $2,000. So this is a really problematic situation, and I think it's dangerous to the strategic concession that the legislature is trying to create to protect Floridians and to make sure that the healthcare system works. That's the big picture. Now, God is in the details, as we all know, and this is where we're probably going to be focusing for the rest of this argument. The issues, really the minute specific issues in this case, I think come down to two questions, right? We have this issue of delegation, right? So the department's responsibilities to effectuate, to implement this health insurance plan are defined in section 110.123 of the Florida statutes, right? That's mentioned a lot in this briefing. Subsection 5 specifically of that statute talks about the department's responsibilities, right? And there's a very long list, A through, I believe it's H or something, of things that the department is required to do, expected to do, the powers and duties of the department. Okay, it does actually go to I of that list. Within that list, subsection C specifically authorizes the department to contract with an insurance company or professional administrator qualified and approved by the Office of Regulation to administer such plan. No problem there. Florida Blue does not, reject the notion that it was contracted with to administer the plan. What does become a problem is the final paragraph of subsection 5. Importantly, that final paragraph is not contained within this list. It's not number J, right, of a sub-list. It's a bump out. It's actually subsection 5. The final paragraph says, final decisions concerning enrollment, the existence of coverage, or covered benefits, that's 3 specific things, shall not be delegated or deemed to have been delegated by the department. So this is an exclusive list of 3 things that are not permitted to be delegated under this statute, which authorizes the department to implement this insurance program. So the question becomes, of course, is setting the rate of payment, Florida Blue's act of establishing this non-network allowance schedule, does that fall within one of these 3 categories? Obviously, it's the appellant's position that it clearly does not.
Can I ask you how this all squares with Section 3C of that same statute at the last sentence that says the department, which refers to DMS, and I guess maybe also DSGI. The department's responsible for the contract management of the state employee health care insurance program, including but not limited to employee enrollment, which we don't care about, premium collection, which we don't care about, and payment to health care providers. So the department's responsible for that. If instead of health insurance, if we were looking at something like just an employee-employer situation, the employer, we'll say, is the state of Florida. The employee is Dr. Gupta here. If he's supposed to be getting minimum wage, because he's not really a doctor, he's just doing minimum wage, and Blue Cross says minimum wage is $10 and cuts him a check for $10, but minimum wage is really $20.
Okay.
If the employer, the state, is responsible for payment of that health care provider, how is it not the one who's on the hook, as opposed to Blue Cross Blue Shield or Florida Blue?
I follow your hypothetical. I believe in that hypothetical, it's a much more accurate portrayal of what Florida Blue is trying to argue, because it cuts some really important details out, right? So we're back to the God or the devil, right, in the details. The point is that Florida Blue is not really responsible for the payment, right, in this scenario. The state is. The state is the one who's
Florida
making
Blue
these
does not owe
payments.
the money. That's what they say.
And that's a liability issue, right? Which is the same as in your hypothetical, I think. So I'd have to agree. In that hypothetical, if Dr. Gupta was just an employee who had agreed to work for minimum wage and he wanted more. But going back to the big picture, Dr. Gupta is providing medical services that are emergency services, right? So
And by law, he's not allowed to charge the patient directly either.
correct. He has a duty to provide those services, irrespective of insurance. And as a counterbalance to that duty, he also has rights statutorily to be reimbursed per that scheme. Those 3 items, the lesser of one of those. That didn't happen here. Now, to continue kind of looking into this particular language that you pointed out in subsection 3, the payment to the healthcare providers issue, the state, the department, agreed to accept that schedule set by Florida Blue. And that's where the real wrench comes into this whole issue. So this is, and if you look at the language, which I've already pointed out in the record at page 939 through 40, there is a very clear requirement, I think, in this plan that the department is going to accept this allowances schedule that was set by Florida Blue. As much as we don't want to think, especially the appellee wants to say that this is non-delegable, that it can't be delegated to Florida Blue, it actually is delegated to Florida Blue in this case, right? There's no question that Florida Blue is setting these non-allowance schedules and that the department is required to use them when making its payments.
Required or chooses to use them?
It must accept. I believe that's the exact language that's in the plan that's attached to the complete. Must accept. Okay, so that's indicative of a requirement if we're looking at that, especially at the pleading stage. And also the pleadings say the same thing. So they are in accord on this point. And so again, I think really what this goes into is the setting of those rates delegable. That's the legal question, right? Because we don't contend there are non-delegable duties, certainly, under Chapter 110, 123, right? there can't be any enrollment final decisions going on by Florida Blue. There aren't any in this case.
You consider the amount of payment to Dr. Gupta to be a benefit?
It is a benefit, but I don't think it's a final decision over covered benefits. That decision was made. This goes beyond that.
The things that can't be delegated again are what?
Enrollment, existence of coverage, and covered benefits.
Okay.
Yes. The appellee contends that this falls within covered benefits, the rate of payment. We suggest that it is not within the category of covered benefits. There are perhaps many disputes that could fall within covered benefits, right? We might have an issue of whether there was a pre-authorization that needed to happen. There are any number of things that could potentially fall within the category covered benefits, and covered benefits is not specifically defined in this part of the statute, right? So we have to actually endeavor to understand this.
Or payment to the healthcare provider is not one of those things that cannot be delegated.
Payment to the
health
health care, the way you phrased it, I would say it cannot be delegated. Payment itself is different than setting a schedule of allowances for the rate of pay to non-network providers. This is a very specific thing, right? The payment is happening. All of those three things I would suggest are not
Rate
at
of
dispute.
payment.
The rate of pay,
You're saying that
correct.
can or cannot be delegated?
I'm saying that can be delegated under the statutory scheme, absolutely, because this is a very specific calculation of the correct payment in this very specific instance. We have a non-network provider that's providing emergency services, also very important because of the duties and the scheme that attaches to that. And now we have a calculation that's being set by an administrator who is trying to say, we have carte blanche to set this rate at any rate we want. Sorry.
Do you agree that now Justice Tannenbaum would disagree with your view right now,
So
based upon his concurring opinions that he wrote in one of the Harrison opinions at the first DCA when he was still on that court?
I follow your question, Your Honor. And as we discussed in the initial brief, really primarily, but also referenced in the reply brief,
What my question was, do you,
I do not believe that he spoke on that in his concurring opinions.
all right.
My interpretation, and I think a very reasonable reading of those concurring opinions, especially knowing and having read many of now Justice Tannenbaum's and actually spoken with him on this issue in a CLE, he was reading that statute, the plain and unambiguous language of that statute very clearly. And when he discussed those three things that we keep talking about, the non-delegable duties of enrollment, existence of coverage, and covered benefits, that case involved a denial of benefits. It very clearly fell within the non-delegable
so
duties.
if I follow along here, then if we wrote an opinion consistent with your argument, and for some reason it went up to the Florida Supreme Court, you perceive Justice Tannenbaum would say, well, they got that right.
I perceive a very live discussion with Justice Tannenbaum. However, within the
Wouldn't discuss
philosophy...
anything with, I mean, they may decide it without oral argument, but I mean...
Correct. So, look, I think looking at the statute word for word and interpreting this, there's a few canons of statutory construction that are required, right? So we're looking at covered benefits. What does that mean? And I see...
You are into your rebuttal time. But
I
you
am.
keep
I
going
just
as
saw.
long as you want.
I'll finish this point up. So, when we're looking at what that term means, we have to look at the overall scheme and the context of the statute is so important, the big picture. I keep going back to that, right? When we have this scheme that's requiring doctors to provide emergency services to out-of-network patients, we can't assume that this term covered benefits is supposed to be so broad as to encompass even the calculation of the rate of pay that would be due to these. That is an administrative task. That's not payment, that's not a liability, that's calculating the appropriate rate of payment. That was not done according to the statutes that are supposed to protect physicians to be able to provide these services. Dr. Gupta was charged this patient $35,000. He only was paid $2,000. For those reasons, this court should interpret this statute as not including the rate of pay in the delegable duties, and it should reverse the order dismissing this complaint.
Okay, thank you. You have 340 in rebuttal.
Thank you.
Yes, sir. Go ahead whenever you're ready.
Good morning. May it please the court.
Yes, sir.
I'm Tim Connor with Holland and Knight, here representing Blue Cross and Blue Shield of Florida, which I'll refer to as Florida Blue. So the ruling below is that Florida Blue is not a proper party to the case. And that ruling is based on what I believe is logically derived from the plan, the statute that implemented and created the plan, and the case law. Now, the judge below ruled prior to the Harrison decisions coming out. However, they were pending on appeal at the time, and we certainly presented the judge below with the trial court's opinion from that Harrison decision, which was on appeal, that laid out some of these issues. I think for purposes of the analytic framework that your honors need to look at in terms of framing up what is the issue to be decided here, that the plan document, the statute, and the Harrison case are the three things that sort of give you the guidance here about what is important. The appellant concedes that Florida Blue is not the insurer in this context. Florida Blue does not have a contract with this plaintiff. Florida Blue does not have a contract with the patient. It didn't issue a policy of insurance. What Florida Blue does have is a contract with the state agency that controls this type of plan. This is a self-insured plan that is made clear from the plan document. And the plan document provides on the very first page of the document itself, under the heading Important Information About the Plan, talks about DSGI has full and final decision-making authority concerning eligibility, coverage, benefits, claims, and interpretation of the plan's benefits document. Now, in the world that I litigate in and day out, use of the term benefits.
This is the world you litigate in?
This is the world I litigate in and day out.
Pull the short straw on that one, or what?
Well, sometimes you do what comes at you, Your Honor.
Appreciate that, yes, sir.
So, but what benefits means is, and what claims mean, is when a claim gets filed by a provider, what is the benefit that is going to get paid out? It's different from
To the healthcare provider?
To the healthcare provider in this instance.
Where do you get that definition from?
So that's how it operates. It's different from the issue of coverage, Your Honor, and we'll talk about that in a minute in the language of the statute.
The insured gets the benefit of being treated, getting the emergency services, the removal of hardware, and all the rest of that Dr. Gupta did that was so necessary, and doesn't have to pay for it other than co-pays, out-of-pocket, deductibles, and that. That's the benefit, right? I mean, that's the benefit typically people would think of under either an insurance policy or a self-insured plan.
So in the broad scheme of things, I don't disagree that that is one aspect of a benefit. The benefits as set forth in the plan document address allowed amounts that will be paid to providers who render service to you. And so that's what I'm talking about, is the benefit amount to be paid. So there are certainly benefits on the patient side of things, but administering the benefit is specifically talking about the payment of the claim that is submitted by the provider in this context. So if we look at...
Even though he's not a party to the contract, that's what you're looking at is the plan now, that he's not a party to?
That's correct. He's not a party to the plan, but he's not a party to any contract.
Right.
And what we have to, I think, focus on here, and the basis for the decision below, is that there is one plan, and that runs between Florida Blue and the state. And the duties of Florida Blue under that agreement are to administer that plan. And this is part of it, to adjudicate benefits. That's part of administering the plan. So, as Your Honor pointed out, in the statute, (110.123), which is the enabling statute that set up this ability to have a self-insured plan for employees of the state of Florida. Subsection 5 is specific in saying the department is responsible for the administration of the state group insurance program. The department shall initiate and supervise the program as established by this section and shall adopt such rules as are necessary to perform its responsibilities. To implement this program, the department shall, with prior approval by the legislature, and then I'm going to skip down to C, and it specifically talks about payments to providers. I'm sorry, I was looking at 5. I meant to be looking at 3, which sets up, the department is responsible for the contract management and day-to-day management of the state employee health insurance program, including but not limited to employee enrollment, premium collection, payment to healthcare providers, and other administrative functions related to the program. So that's one description. You then go over to 5, which I started to read through. And at the very end of 5, it says, final decisions concerning enrollment, comma, the existence of coverage, comma, or covered benefits under the state group insurance program shall not be delegated or deemed to have been delegated by the department. And that's, I think, important language, because when you're talking about the determination of benefits, you are talking about the amount that's going to be paid for a given claim. That is different from, and it's separated by commas in the language of the statute, it's different from a determination of coverage. And I think what the appellant's argument is attempting to do is sort of conflate those two things.
In the state plan, does it talk about rates of reimbursements to healthcare providers as a benefit? Does it use that language?
It does. Well, it outlines, Your Honor.
I mean, very, very precisely, I want to know if it calls reimbursement to healthcare providers a benefit.
It does, Your Honor, and it sets out tables.
What page is that on?
Well,
because again, and it certainly may be there, but I typically think of benefit as the benefit goes to the insured, or here the member covered by the plan.
So, Your Honor, I think it is sort of throughout. If you, and I don't have the record citation in the plan I'm looking at, but there are a number of places where it is outlined. For example, Section 1 of the benefit plan is entitled Standard PPO Options Summary of Benefits. And then it runs through this table of what is reimbursable to the provider that you go see. And so, for instance, It's page 65 of the document. I apologize, I don't have the
I can
right
find it.
site, but it talks about emergency room procedures, hospital services, so that would be the facility, and physician services, that would be the plaintiff here.
Does it say how much will be reimbursed?
It says 80% of the allowed amount after the copay. So what that is saying is it doesn't have a specific dollar amount.
That's then a copay or a deductible provision, correct?
Yes, and it says,
That limits the benefit to the insured or plan member. Instead of 100% coverage, you may have to pay a copay, you may have to meet a deductible, you may have a co-insurance,
yes.
right? It doesn't say how much we're paying the healthcare provider.
No, and it can't possibly, because if you think about the number of CPT codes that get utilized for determining what service was rendered and how that gets calculated for each CPT code.
Doesn't
and
even
then-
say the basis for reimbursing, does it, at that point?
It says of the allowed amount.
Right, but the allowed amount is what we're here about.
And the allowed amount is then set out as, I think, Your Honor, Judge Soud asked about, is that the amount that the state is required to accept, or is it what they choose to accept? And the answer is it's what they choose to accept, because you have to understand that the state negotiates this, there's a fairly significant process in negotiating what is this plan going to look like, who's going to administer it, et cetera. The state makes that decision about what are going to be covered benefits, what are going to be payments. Just because they agree to accept doesn't mean that they're delegating their responsibility. It shows, frankly, that they are exercising that discretion they have to accept something. And as the language of the statute says, they're not delegating it, and they can't be deemed to have delegated it. It's the state's responsibility. At the end of the day, it's a self-insured plan. It's the state's money. It's taxpayer dollars. And just because they accept a rate that is being established by Florida Blue doesn't mean that they've delegated, as a matter of law, the responsibility for determining that rate.
Did they reimburse at a greater rate than what's in the plan, or would you guys not agree to work with them then? I saw somewhere in your plan it says you don't want the state paying out-of-network people more than in-network because you're worried people would then bail out of the network to get more money.
Well, I mean, Florida Blue acts at the direction of the state. If the state said, we want you to pay more money to this out-of-network provider, it's the state's money. It's not Florida Blue's money. So Florida Blue is simply administering this plan in accordance with what the state has told it to do. So it instructs Florida Blue what to do. It's the state's decision at the end of the day. And that money, even though Florida Blue may adjudicate a claim and write a check, that money is then actually funded by taxpayer dollars from the state.
Going back to my very simplistic example of minimum wages, in that role, you would say that Florida Blue is like a payroll company, like ADP or something. Here's my payroll from the state. You guys write the checks. If the amount's wrong, it's not your fault as long as you follow the numbers the state gave you, correct? And as long as they've adopted this rate of reimbursement, that's the state's decision to do it and their responsibility if it's an incorrect rate.
Yeah, in that hypothetical, Your Honor, that you are acting to implement at the state's instruction, and that is your obligation. That is one of the things, by the way, that in the Harrison case was a key point. The duties that Florida Blue has run to the state. That's the contract that exists. The duty is to administer this plan. And if I could just reference in the Harrison case, I'm going to reference the opinion that is at 412 Southern 3rd, 895, because there's a couple of different opinions. This was the appeal involving Florida Blue. There actually were two appeals filed, and they were handled simultaneously. One was Florida Blue, one was the state agency. And we argued them together in front of the same panel. Exactly what happened below is what happened in Harrison. The court relied upon the plan, and it said, among the reasons for our affirmance, and there were multiple reasons, obviously, that were argued, is that the state employee's PPO plan attached as an exhibit to the second amended complaint conclusively negates the individual causes of action that Harris sought to allege. And that's part of what happened below. That plan conclusively negates the claims that Dr. Gupta is attempting to allege here. Judge Tannenbaum, now Justice Tannenbaum, in his concurrence, though, at the very beginning says, the appellant sued Florida Blue regarding how it administered Florida's group insurance program for the Department of Management Services. Same thing here, administration of the plan. The trial court dismissed the second amended complaint with prejudice. Not only did the appellant fail to sufficiently plead either a contract or other source of duty owed to him by Florida Blue, but also by law, final decisions concerning enrollment, the existence of coverage, or covered benefits under the state group insurance program, or are authority that cannot be delegated or deemed to have been delegated by the department. The appellant's dispute is exclusively with the department. Florida Blue's duties and obligations being owed to the department, not the appellant. And then he goes on to talk about his other concurrence as well. And that's the main point here, I believe, is that there's not a duty that flows from Florida Blue to this plaintiff on which Florida Blue can be sued. Its duties run to the state to faithfully administer this plan pursuant to how the state says it wants the plan to be administered.
Is it overly simplistic to suggest that the fact that the PPO plan here is a self-insured plan of the state of Florida through the Department of Management Services, through the Division of State Government Insurance, the fact that it's self-insured, that is either determinative or nearly determinative of this case?
I don't think that's overly simplistic at all, Your Honor. I think that is the key factor because it is the state's money and they contract with Florida Blue to administer that plan and issue payments from taxpayer dollars. So I do not think that is an overly simplistic way to look at it. Now,
Can we tell from the opinion itself that you're referring to whether Harrison is a member of the plan or a healthcare provider?
Harrison...
You might know from other sources, but I'm looking at the opinion.
Harrison was a member of the plan. He was a state employee.
So he definitely is, he would be referring, he, she, whatever, would be referring more to what my concept of benefits is. I think I'm covered, I think you guys should have paid for this and you're not paying for it.
Yes, and
You
then...
can't really tell what the dispute is other than they don't have one. Right?
Well, it's true that the court doesn't go into explaining exactly the
Explain
position
much.
that Mr. Harrison occupied.
Right.
I mean, you know, I know that because
Right,
I
'cause
was
this
the
is the
lawyer
world
in the
you live
case.
in, right? So,
And that certainly was abundantly clear in the record of that case, but he was a member who said, I'm not getting the benefits that I think I'm due. And he filed a suit, and I see, am I over now?
You're over now.
I'm over now, okay. Okay. Your Honor, I think we sufficiently made our arguments in our brief as well. I appreciate the time today and the questions, and I will wrap it up just by saying we ask that you affirm the decision below.
Okay, thank you, counsel.
So I'd like to start off my rebuttal where we left off, essentially, from the appellee's presentation, and that's in the Harrison decisions, okay? So Judge Edwards, I think you brought out a really good point about why this case is distinguishable, why it's really not analogous with the Harrison trilogy. The fact that we have a provider of emergency medical services here. Again, that big picture is so important to keep in mind
Why
in the
is that so
context.
important?
It's because it's the context in which we're interpreting these statutes. We have a scheme in Florida, a statutory scheme, to try and create an environment where medical providers are not rendering services based on whether they're in-network or out-of-network. How problematic would it be as a doctor if you put yourself in the position of a doctor in an emergency room and you're providing these services because you have a duty to, before you look at insurance, before you ask for insurance, before you determine what course of care is medically necessary, you cannot.
Isn't the emergency room doctor aware of that scenario and
Correct,
can
but
choose to whether to continue on as an emergency room doctor or not?
that is correct to a certain extent, Your Honor. However, there is a scheme in place to encourage these providers, whether it's even in the back of one's mind, to know, oh, well, this guy is in network. I might only get $2,000
And
of
I'm
something.
not unsympathetic. My wife was an emergency room nurse
Certainly.
for 35 years.
But again, this is only relevant to the context in which we are construing these. And when we have counsel up here saying that Harrison is precedential, that Harrison must be followed, we can't overlook the fact that the situation of the plaintiffs is completely different. It's not analogous. This is not what then Judge Tannenbaum had in front of him when he was opining about the situation of the statute. We actually had a denial of benefits. That falls squarely within those 3 non-delegable duties, and we take no issue with Harrison. We are distinguishable from Harrison because we have a situation that does not fall within those categories. Really important point when we're talking about the meaning of words, and I think the beginning of the appellee's presentation started more with talking about what is a benefit, right? How do we define that? It's not defined in the statute. Let's look at the actual plan. Okay, so if you look at page 1005 of the record, that's the definitions that this policy gives. Okay, so we have benefits or plan document. I don't have the paper, but I do have a screen, right? So this document, your insurance coverage, right, is limited to the express written terms of the benefits document. Your coverage cannot be changed based on statements or representations. Okay, it's about coverage, okay? The words that are used in the statute, the exact words that are used in the statute that contains these exemptions, right? 110, 103 sub 5, covered benefits. Covered benefits. That's what we're talking about. We're talking about the benefits themselves, not the rate at which they are reimbursed to emergency out-of-network providers. Dr. Gupta does not fall within the definition of covered benefits for the purposes of Florida Blue benefiting from this exemption here.
If the department remains as under the statute that they're responsible for reimbursement or payment of healthcare providers,
Correct?
regardless of what happens with Florida Blue, will you still have a remedy against them, against the department?
So I think this is why the declaratory action is so important here, because you do have a very odd situation where we need a declaration from the trial court that this rate either was or was not in compliance with the statutorily required scheme, okay? How that then will relate to what the state or the department actually has to pay out is another issue, but really quickly, I see my time is out. encourage you to look at page 1008, which does define actually the non-network services schedule, the non-network allowance, excuse me. That is a defined term. And in that it says the maximum amount this plan will approve. It's mandatory. It's in the policy. The state will not approve anything greater than what Florida Blue sets in that non-network allowance plan. For those reasons, this order dismissing the amended complaint must be reversed. Thank you.
All right, thank you, counsel. Okay, very well argued. We will stand adjourned.